Hello everyone, welcome back. As I have already done some aspects of citizenship, today I will be covering few more related concepts. In my previous lecture, I was telling you about the arguments against Citizenship Amendment Act. Few points were already covered and the rest I will continue now. The next point is disallowing citizenship to Muslim refugees of Afghanistan. Large number of Muslim refugees from Afghanistan have taken shelter in India since Russian invasion of 1979. Out of 2 lakh refugees of then, only 5,000 were Hindus and Sikhs and Christians, whereas rest were all Muslims. India gave them shelter on humanitarian grounds at that time, and now they will be disallowed citizenship because of religious and political issues. Even if they want, they cannot go back to their country and hence will lead an undignified life. Another argument, it infringes United Nations conventions. Article 15 of the Universal Declaration of Human Rights states, everyone has the right to nationality and no one shall be arbitrarily deprived of his nationality nor denied the right to change his nationality. Furthermore, the United Nations High Commission on Human Rights mentions international human rights law provides that the right to states to decide who their national are is not absolute and particular. States must comply with their human rights obligations concerning the granting and loss of nationality. The Citizenship Amendment Act goes against the international standards as well as universal human rights law by allowing citizenship to some and disallowing citizenship to many. Another point, CAA or NRC represents another policy blunder. India's participation in Bangladesh War of 1971 was a historical mistake that caused migration of nearly 10 million refugees from Bangladesh. Then, this led to the question of granting citizenship to these refugees, which resulted in Assam Accord of 1985, guaranteeing deportation of people who migrated from Bangladesh. This was an instance of blunder committed by the government by granting citizenship to refugees or illegal immigrants. Another point of argument, misleading information on infiltrators and on missing Hindus in Pakistan. There is no correct information on record with the ministry as to how many infiltrators are there, and such blatant information misleads the public at large. Bangladesh is more developed in comparison to India. It is wrong to assume that people will flee from Bangladesh to India in large numbers as illegal immigrants. This is because Bangladesh is better than India on many human development indices since many years. Its GDP is even better in comparison to India. So there is no question of people coming to India, rather the trend will be reversed and there will be migration of Hindus to Bangladesh. With all these arguments, major protests against the act were held at different universities in India. Students, especially from Jamia Millia Islamia University, Aligarh Muslim University and JNU, alleged cruel suppression by the police. These protests led to death and injuries to many people, damage to the public as well as private property, detention of several people and suspension of local internet as well as communication infrastructure in some affected areas. Subsequently, many state governments decided for non-implementation of this act, but the central government reminds them of their absence of any legal power to discontinue with the execution of the said act. Now, let's talk something about the opinion of Supreme Court on Citizenship Amendment Act and the international intervention. After the scorching arguments on the passing of this act, large number of petitions have been filed in the Supreme Court challenging the constitutional validity of Citizenship Amendment Act 2019. The Supreme Court on 18th December 2019 decided to examine the constitutionality of the Citizenship Amendment Act 2019 but rejected to stay its implementation as the court was of the opinion that it cannot pass any ex parte order without hearing the centre on CAA. Therefore, on 22nd January 2020, the court, after hearing nearly 144 petitions, gave the government 4 weeks' time to respond to the pleas filed against CAA and said that it will pass an order of granting interim relief to the petitioners after these 4 weeks' time, if any. The court further added that the Constitution bench of 5 judges will be set up to hear large number of petitions against CAA. The Citizenship Amendment Act 2019 has not only got criticism at national levels but also from many international authorities. The United Nations Special Rapporteur on Minorities, Fernand de Warnes, stated, "Many have opined that the exclusion of Muslims as a group from the ambit of the law constitutes an extreme example of discriminatory treatment and that the right of equality without discrimination, particularly if it has a racial element, is one of the fundamental principles of international human rights." Also, while the matter was pending in the Supreme Court, the United Nations High Commissioner on Human Rights, Michael Ballet, intervened in the Supreme Court by joining the petitions challenging the Citizenship Amendment Act 2019. They informed the Supreme Court that her office has filed an application recommending the Supreme Court to make the United Nations as a third party in a petition filed by a former civil servant against CAA. Bachelet emphasized that the sovereign power is not unfettered and the verdict concerning citizenship have to conform of the standard of non-discrimination. In response to this, the spokesperson of Indian Ministry on External Affairs, Ravish Kumar, said that the citizenship is an internal matter and no international authority has the power to intervene into Indian Parliament's sovereign right to make laws because no foreign party has any locus standi in this context. The idea behind Bachelet's intervention was to highlight the High Commissioner's concerns that the Act of 2019 does not comply with India's human rights obligations. Another spokesperson with the Office of the United Nations High Commissioners for Human Rights, Jeremy Lawrence, said, "Although India's broader naturalization laws remain in place, these amendments will have a discriminatory effect on people's access to nationality. It appears to undermine India's commitment to equality before the law as enshrined in its constitution." He added further that last December, India joined the international community in endorsing the Global Compact for Safe, Regular and Orderly Migration, which commits countries to ensure that all measures governing migration are based in human rights. All migrants, regardless of their migration status, are entitled to respect, protection and fulfillment of their human rights. According to Mr. Lawrence, the Supreme Court of India will review this legislation and will cautiously consider its compatibility with India's international human rights obligations. Moreover, a lecturer at the Eric Castren Institute of International Law and Human Rights at the University of Helsinki, Parvathy Menon, stated, "What the NRC will create is a large group of stateless people, which in itself will run counter to the obligation in international law to prevent statelessness." Menon also pointed out that the returning many Rohingyas is a clear-cut violation of international obligations, that is, principle of non-refoulement under refugee law. This clearly justifies that Citizenship Amendment Act has induced acute reactions from the international community as well. There are many other instances where the Indian government has been criticized for passing Citizenship Amendment Act. The protests against CAA is achieving high impetus across the globe, like in Boston, Chicago, Hague, etc. And India's image as the world's liberal democracy has undergone a scrutiny. Now let's talk something about Citizenship Amendment Act vis-a-vis NRC, that is, shifting of spotlight from CAA to NRC and NPR. As soon as the Citizenship Amendment Bill was passed in both houses of Parliament and given presidential assent for making it a law, ear-splitting murmurs started about another issue, that is NRC, which is known as National Register of Citizens. When the hot words on the implementation of CAA were going on, the Union Home Minister Amit Shah announced about the nationwide NRC. Citizenship Amendment Act 2003 sets legal framework for nationwide NRC. NRC is a National Register of Citizens, which is just an official count and record of legitimate Indian citizens. It includes all the demographic information of those who qualify to be the citizens of India as per the Indian Citizenship Act 1955. So protests have exploded not only against the passing of CAA but also against the creation of NRC in India. Along with this, on 24th December 2019, the central government also approved for the NPR, that is National Population Register, that contains a complete identity record of every usual resident in the country. NPR is being prepared at the local, sub-district, district, state and national level according to the provisions of Citizenship Amendment Act 1955 and the Citizenship Registration of Citizens and Issue of National Identity Cards Rules 2003. The NPR was updated in 2010 and the particulars were collected along with the Census of India 2011. The data collected for NPR will be used for preparing NRC, and the NPR-NRC is considered a forerunner of catalyst for the operation of CAA in the country, which fast tracks the citizenship process for illegal migrants from Pakistan, Bangladesh and Afghanistan. The Citizenship Amendment Act 2019 excludes illegal Muslim migrants within its domain but does not exclude legal Muslim migrants. The Act is providing Indian citizenship to illegal non-Muslim migrants of these three countries. This implies that the illegal migrants of those three countries will be included in NRC. If yes, then how can it be justified? One way, through CAA, we are providing citizenship to illegal migrants, and other way, through NRC, we are trying to shun out illegal migrants from the country. But there is a fear for Muslim legal migrants, because if they fail to furnish adequate proof of citizenship as they are not covered in the CAA, then they will be deemed as illegal migrants. So, the Muslim people will be highly victimized in this case because neither they are included in CAA and nor they will be given the status of Indian citizens under NRC if failed to furnish the proof. This becomes a clear violation of secular fabric of the country, where the citizenship will be denied on the basis of religion, if not directly but of course indirectly. NRC is not discriminating on the basis of religion, but CAA does. This discrimination on the basis of religion is against the India's secular ethos, especially when the Act does not mention that it is covering only those people who have faced religious persecution. The Act is shielding number of non-Muslim illegal migrants while making large number of illegal Muslim migrants stateless people. Accordingly, CAA is a life jacket and NRC is about pushing everyone out of the plane so that they prove themselves all over again. However, Muslims are not getting this life jacket. This implies that distributing life jackets only to few people is not problem, but punishing everyone out of the plane, including Muslims, is the actual problem. While CAA and NRC were on the row of protest in the country, another controversy erupted over the updation of NPR. But the question is whether there is any nexus between CAA and NPR. The answer is partially yes and partially no. The link can only be developed on knowing how the government used the data collected for NPR. In order to understand its linkage, one needs to recall the Citizenship Amendment Bill of 2003, where Section 14A was inserted, which provided for issue of national identity cards. According to Section 14A of the Act of 2003, the central government may compulsorily register every citizen of India and issue national identity card to him. The central government may maintain a national register of Indian citizens and for that purpose establish a national registration authority. On and from the date of commencement of Citizenship Amendment Act 2003, the Registrar General India appointed under subsection 1 of section 3 of the Registration of Births and Deaths Act 1969 shall act as the National Registration Authority, and he shall function as the Registrar General of Citizen Registration. NPR is the first step towards NRC. Many states have been opposing it vehemently, as Bengal being the first one. NPR was originally sorted to be prepared between April 2020 to September 2020, and its groundwork has already been started. Section 14A provides for the legal basis of preparing NPR and linking it with NRC and census. According to the provision, the Registrar General of India shall act as National Registration Authority as well as Registrar General of Citizen Registration. The catchy point here is that Registrar General also acts as Census Commissioner of India. This implies that the data collected for NPR may also be used for NRC. If the government so desires and if the data is used for NRC, then the same will act as a groundwork for identifying illegal migrants as mentioned under CAA. Therefore, it is not incorrect to say that CAA is a subset of NRC and NRC is a subset of NPR. Deliberating upon NPR and NRC is the current exercise of the government, which has been working on since past amendments in the Citizenship Act, but CAA is more like adding fuel to fire. Hence, many demonstrations have risen up against CAA and conducting nationwide NRC. The reason for not conducting nationwide NRC is the unsuccessful and terrible results of NRC conducted in Assam. So let's discuss little about what is and how is NRC in Assam working. Except in the state of Assam, this exercise of NRC has not been carried out anywhere in the country. The exercise of NRC in Assam had been a bad experience of the government because many bona fide citizens were left out of NRC for not able to prove their ancestors' past citizenship record. The Citizenship Act 1955 states that anyone born in India on or after January 26, 1950 till 1st July 1987 shall be an Indian citizen by birth. Anyone born on or after 1st July 1987 but before the commencement of the Citizenship Amendment Act 2003 and either of whose parents is an Indian citizen at the time of his birth shall be an Indian citizen by birth. Anyone born after the commencement of the Citizenship Amendment Act 2003 and both of whose parents are Indian citizens at the time of his birth shall be again an Indian citizenship by birth. The only exception to this was Assam, because as per the Assam Accord of 1985, a memorandum signed between two students groups and the Union Home Secretary in the presence of then Prime Minister Rajiv Gandhi for culmination of a 6-year-long agitation demanding expulsion of illegal migrants from Bangladesh, foreigners who came to Assam up to March 24, 1971 were to be regularized as Indian citizens only. Accordingly, only Assam was allowed to take foreigners up to March 24, 1971 as Indian citizens, and for the remaining country, whosoever is born outside the country after 26 January 1950 and residing in India without any proper documentation record will be treated as illegal immigrant. Such persons were then subject to laws like Foreigners Act 1946 and the Passport Act 1920. NRC has been a state-specific exercise in Assam. The first NRC in Assam was carried out in 1951 when there were widespread allegations of massive illegal immigration from East Pakistan, which is now Bangladesh. The second NRC in Assam was carried out in 2015. It happened in 2013 when Assam Public Works and Assam San Milita Mahasangha and others filed a writ petition before the Supreme Court requiring the deletion of illegal migrants' names from the voters list in Assam. Hence, the process of updating the National Register of Citizens in Assam in accordance with the Citizenship Act 1955 and the Citizenship Rules 2003 began after the Supreme Court's order in 2014. Accordingly, the BJP government supported for the implementation of NRC in Assam as per the orders of the Supreme Court of India in 2015. Nearly 33 million people were residing in Assam who were supposed to prove their citizenship or that they were Indian nationals before 24th March 1971. In Assam, firstly, one had to produce a documentary proof issued before 24 March 1971 like the 1951 NRC or the electoral rolls up to 24th March 1971 just to prove that his or her ancestors were residing in India before that date, and secondly, one has to produce the document showing his or her relationship with those ancestors. Thinking very prudently, it is not an easy task for everyone, especially in a country with such poor documentation record, culture and meagre financial sources. The final list of NRC of Assam was released on 31st August 2019. Resultantly, approximately 1.9 million people failed to make themselves fall in the NRC, and still there is no lucidity as to how many illegal immigrants were identified during this exercise in Assam. Those who were left out from the NRC list can approach to Foreigners Tribunal for its decision. Nearly 200 Foreigners Tribunal were set up across the state for this matter. Further, if any person is not satisfied with the orders of Foreigners Tribunal, then he or she can appeal against it. Also, for these persons who have not been listed in NRC, detention camps were set up. Presently, there are 6 detention camps in different districts of Assam, that is Golpara, Dibrugarh, Jorhat, Silchar, Kojrajhar and Tezpur. On a careful and logical analysis of NRC conducted in Assam, it can be stated that all those foreigners who were allowed to come to Assam up to 24th March 1971 and they were initially given the status of Indian citizens was now treated as illegal migrants because majority of them was not having any documentary proof to justify their citizenship, and so they became stateless. Hence, this was considered as a dreadful move of the Indian government. Now, let's throw some light on NRC in India. NRC is an official record of Indian citizens. This register was first prepared after the 1951 census of India, and since then it has not been updated till now. Ever since the implementation of NRC in Assam, there has been a rising demand for its nationwide implementation, and India's Home Minister Amit Shah on 20th November 2019 has hinted upon the expectancy of nationwide NRC. Many top BJP leaders have affirmed that like NRC was conducted in Assam, the same will be implemented all over in India. In this context, it has been suggested that a new legislation should be drafted which will enable the government to identify infiltrators who have been living in India illegally and then deporting them to the country from where they came. This will be done in order to shun out the illegal immigrants from the country, which Amit Shah referred to as the termites. This is just a proposed bill, and if drafted as well as executed, will target illegal immigrants in India, but not the Hindu, Sikhs, Christian, Parsis, Jains or Buddhists coming from Afghanistan, Pakistan or Bangladesh if they claim that they arrived in India as per the provisions of Section 2, Subsection 1, Clause B of the Citizenship Amendment Act 2019 and after facing persecution from these countries. This would essentially imply that if nationwide NRC will come, then illegal immigrants from other than Afghanistan, Bangladesh and Pakistan will be affected, and also from these three countries if anyone belongs to Muslim religion, that will also be affected as they are not included in the Citizenship Amendment Act of 2019. As a result of the implementation of the nationwide NRC, the affected persons will be detained and will kept in detention centers as what happened in Assam. Thereafter, Ministry of External Affairs will contact those nations and be in touch with their record. If the details of detainees are matched with the records of other nations and also those nations are ready to accept these people, then the deportation of such detainees will take place. No doubt, Amit Shah said that the government will make NRC nationwide by 2024 with intent to detect illegal migrants, but our Prime Minister Narendra Modi ji said that his government has never passed such statement about nationwide NRC concept. Also, as of now, the government has denied the use of CAA for updation of NRC in India, and they contended because NRC hasn't been finalized yet, so there is no question of linking CAA with NRC. That's the main part of CAA, NRC and NPR. Let's come to some concluding part. It is seen for the first time that the country has incorporated a religious criteria into its citizenship policies. India is in a lockdown situation after this Amendment Act of the government, and the same has been challenged, thereby leading to a pandemonium in the country. It is no doubt that giving shelter to persecuted persons is a welcome move for any country, but making it an innate for some and not for others is not acceptable to the society at large. Many states like Kerala, Punjab, Rajasthan and West Bengal have passed a resolution against the Act because they claim that the Act does not stick to secularism. As CAA is already a problematic issue prevailing in the country, and the NRC exercise as planned by the government, if implemented, will prove even more disastrous. It appears to few that CAA, NRC and NPR will create a majoritarian state and secular citizenry will swept aside. The government has not framed out any guidelines in this regard, and if it is done arbitrarily by depriving people of their citizenship rights, then it would be clear infringement of the basic fabric of the constitution, that is secularism. There is no doubt that government is shielding the illegal immigrants from different nations, which is itself a good move for maintaining cordial relations with the government of those countries. But at the same time, discriminating on the basis of religion for the purpose of granting citizenship is not acceptable democratically under the shade of Constitution of India. This implies that CAA is not awful, but it should have balanced all the religions while granting Indian citizenship so that the secular culture of our country remains maintained. India as a country follows the ideology of Vasudhaiva Kutumbakam, should not be hasty in taking decisions that can disenfranchise her citizens, contradicting its centuries followed values. Even the apex court of the country did not pass any order against Citizenship Amendment Act as of now and tried to deal with CAA under mixed signals. The Supreme Court of India did not pass any ex parte order against CAA, rather gave the government some time to file its reply. But the matter has been temporarily suspended because of the lockdown issues that were going on in the country. So if the highest court, that is the guardian and protector of the fundamental rights of citizens, is silent on the constitutional validity of CAA till the time, then we the people of India must not also condemn CAA in its all aspects. So if the highest court of India, that is the Supreme Court, is silent on the constitutional validity of CAA, then we the people of India must not also condemn CAA in all its aspects. Now, the only complacency on the CAA will be brought by the Indian judiciary, which is crumbling these days under the citizenship crisis, as it is to answer all the staunchest protagonists as well as antagonists of Citizenship Amendment Act of 2019. Thank you everyone for your time and attention. We have covered the entire concept of Citizenship Amendment Act 2019, and I hope that all the listeners have understood the topic. Stay safe, stay healthy. God bless you all. Take care.